Thank you for joining us for this installment of Business Break. We hope you've been following along the series and have found the videos to be practical and useful. My name is Jeff Daniels, and for this video, I will be joined by my colleague, James McTagg. The purpose of this webinar is to outline some considerations that can assist businesses when dealing with debt. I will briefly outline the fundamental requirements of a contract and why it's good practice to have written contracts governing businesses' various relationships. And then James will provide an overview of the Limitations Act and discuss the importance of the Interest Act and how a business can best ensure that interest on overdue amounts is actually enforceable. Now, contracts are a fundamental part of every business, and the majority of a business's relationships, whether it be with suppliers, customers, or even employees, are based on contract. So what is a contract? Well, to put it very simply, a contract is a mutual agreement between two or more parties. It's not something that's imposed on one party by the other. It has to be something that's agreed to. It can be oral or it can be in writing. So there's three essential elements to establish a contract. First, there must be an offer. Second, there must be an acceptance of the offer. And third, there must be some consideration, meaning that there's something of value that is exchanged between the parties. So as long as these three elements are satisfied, a contract can be binding on the parties, even if it is just a handshake deal, something that's reached orally, or something that's reached by an exchange of emails or text messages. Whether a contract is written or oral, the contract should document the essential aspects of the business relationship or the transaction that the parties are concerned with. This includes, importantly, who is involved. Is it an individual or is it a corporation? What needs to be done? What price is going to be paid? When is payment required? And what happens if payment is not made in time? Now, why is it important or good practice to have written contracts? Well, a written contract, like any contract, should set out the essential terms of the arrangement. But when it's in writing, the parties can refer to the contract in the future in the event there's a misunderstanding or a disagreement. The inherent problem with oral contracts is that it's difficult to determine exactly what was agreed to when the contract was made, especially if there's been a lot of time that has passed or the arrangement of the parties has changed since the contract was initially entered into. Having a written contract will reduce the likelihood of misunderstandings and disagreements between the parties and can help promote a successful and ongoing business relationship. Now, from an enforceability perspective, it is definitely advantageous to have a written contract, especially if it becomes necessary to prove what was actually initially agreed to. The written contract is the most objective form of evidence available. Now, if a party is seeking to recover debt and needs to take legal action, that party has to satisfy a burden of proof, meaning they must establish that a contract existed and establish that the contract was breached. It's much easier to meet this burden if you have a written contract, as the existence of the contract is probably not going to be brought into question, or if it is, it can easily be satisfied by pointing to the written contract. And determining a breach should likely be pretty evident when examining the written contract itself. You're not dealing with the disadvantages of having an oral contract where there could be a dispute as to whether or not the parties even had a relationship to begin with. A written contract can also establish important things that can assist a business when attempting to recover business debt, such as when must a legal action be commenced and whether or not a party is entitled to interest on overdue amounts. And James will be discussing this with you shortly. Now, if it's too impractical or inconvenient to have a written contract for every relationship, it is at least advisable to make sure that the essential terms of the contract are recorded and understood by the parties. And one simple way of doing this is to put the basic terms in an email, send it to the other party, and request that they acknowledge it with a response. I'm now going to turn the webinar over to James, who will discuss the Limitations Act and the Interest Act with you.
Hello. So the most important thing to consider when you're looking to collect business debt is how long do you have to start a claim? In Alberta, the Limitations Act sets out the basic 2-year limitation period. This means that one must commence a claim to recover the debt within 2 years. If 2 years has passed, one can still commence an action by way of a lawsuit. However, if the defendant pleads a limitation defense in response, they are likely to be wholly successful and the claim will be dismissed. The additional downside is that the opposing party will likely also be awarded costs against you. There are two key limitation periods in Alberta. For discoverable claims, the limitation period is 2 years, and for claims that do not depend on discoverability, the ultimate limitation period is 10 years. The ultimate limitation period is less frequently used and essentially sets an absolute end date, meaning events that took place more than 10 years prior to an action being commenced are barred regardless if discoverable or not. I will note that there are some very narrow exceptions to these limitation periods. However, they do not generally apply in the business context. So when does the clock start to run? The point that is generally the most contentious with respect to limitation periods is when does the clock start to run and when does that 2-year limitation period actually begin? The Limitations Act and the Alberta case law determine that the clock begins to run in accordance with the test mentioned. And this test is when that the claimant knew or ought to have known that the injury occurred, the injury was attributed to the defendant's conduct, and the injury warrants bringing a proceeding. If all three of these factors have been met, the limitation period commences and one has 2 years from that period to file a claim. For example, if one issues a series of invoices for a project and the project has still not been completed in full, the limitation period does not start to run from the date the project has been completed. Rather, it starts to run from when the party has become aware that the payment for that specific invoice has not been made. Generally, for debt claims, the 2-year limitation period is utilized, and this period commences on the date the amount is due in the invoice. This is sometimes the actual date of the invoice, or sometimes invoices specify that they're payable within a certain time period, such as payable net 30 days. For the 10-year limitation period, the test is not applicable as this period does not depend on discoverability. The claimant's knowledge of the specific act is irrelevant. This period is sometimes used in construction matters where the negligent act is not immediately discoverable. This is generally not a limitations period that is applicable for business debt. Usually that is the 2-year limitation period. Next, I'm going to briefly consider contractual interest rates and how they're enforceable. So many businesses have clauses, either in a contract or on an invoice, that indicates interest will accrue on outstanding or unpaid accounts at a certain rate. The rates that are common in Alberta are often in the 15 to 24% range. The Interest Act is a federal piece of legislation that determines what interest provisions will be enforceable, regardless of what the contract says or an invoice says. Firstly, as Jeff discussed about contracts, a specific interest rate will be a term of the contract that must be agreed to between the parties. Although it is common practice to list an interest rate applied to overdue accounts on the invoice themselves, this will generally not be enforceable if the rate was not specified in a contract. The court will see this as one party unilaterally imposing a contractual term on the other party. For contractual terms to be enforceable, both parties have to agree to the terms. One can get around this issue by having a written contract for the services that specifies the applicable interest rate on overdue accounts. The contract can be in the form of a credit application, a contract for the services, or as Jeff mentioned, the acceptance of essentially a quotation. The next point I wanted to briefly touch on is a common mistake that results in many contractual interest rates being unenforceable. Many contracts state that interest will be charged at the rate of 2% per month on outstanding accounts. The Interest Act requires that a contractual provision specify a particular interest rate at a specific rate for a period less than a year. It must include the per annum rate to be enforceable. So if the per annum rate is not included, the Act indicates that a rate of not more than 5% per annum shall be charged. So essentially, what you're required to do is you're required to list a per annum interest rate in addition to an interest rate for per day or per month or any other shorter period than a year. The proper way to list the 2% per month charge would be to indicate that the interest accrues at the rate of 2% per month, but also indicate that this would be 24% per annum. That way, a court would find it complies with the Interest Act and would be enforceable. In the time allotted, we are only able to briefly touch on a couple areas. If you have any questions about dealing with the collection of business debt or seeking assistance with the collection of business debt, please let us know, as we would be happy to assist. Thanks for watching.